Good morning, everybody, and thank you very much. It's a privilege and honor to be here. Let me jump into it since we have time constraints. What I'm going to talk about today is international law and the use of international law on two fronts. One, as a sword, and the second as a shield. A sword in the sense, or a shield in the sense that it will allow governments like the Malaysian government to have halal certification processes to protect the integrity of the supply chain and the certification. And on the other hand, the ability to use international law to overcome what I would call a discriminatory legislation that may be passed by various governments, which in some way I think would both stigmatize religious slaughter and religiously certified food products, and at the same time impose barriers to trade in those products. Let me just jump right into it. The 4 points that I think that I'm going to cover today is I'm going to give you a quick and dirty. We could spend days or weeks or even years discussing these matters, but we don't have that time. I'll give you a quick overview of public international law. Then once we do that, we will go into the status of halal in the eyes of the public international law. And then, as I mentioned, we will finish up by talking about the use of that law to protect halal integrity, which I would call using the law as the shield, and then the other way, which is the use of public international law to overcome discriminatory legislation, and I'll give you some examples there as well. All right, a couple of points here on public international law, and there are really two camps. I'm going to focus primarily on the law and agreements relating to the World Trade Organization, which I'm sure many, if not all of you, have heard about. And basically, there are agreements among and between governments that are signatories and members of the World Trade Organization. And these agreements govern the conduct and relationship between nation states. So what kind of laws you can pass in your own country and how those will impact upon the businesses in other countries and the citizens or businesses associated with those other countries. Now, this issue of public international law is sort of two sides of a coin. One side is where you have agreements between governments and only the governments can complain or bring dispute processes against each other. That's the World Trade Organization. That's going to be the primary focus of my discussion this morning, although I'll quickly flag up the private side. So, as I mentioned, you have the WTO, which is the World Trade Organization, and you'll see a lot of different acronyms there. And basically the WTO governments or WTO signatories have agreements between each other. And these agreements speak to a variety of issues. The first one is called the TBT agreement, which means the Technical Barriers to Trade Agreement. SPS agreement, which many of you have heard of, which relates to protection of animal health and plant health. GATS, which relates to excise and tariffs, and TRIPS, which relates to intellectual property. Look, the bottom line is there are large amounts of agreements, but if you had to boil down kind of the primary issues that are relevant to you all, it would relate to 3 points. Number one, governments should not pass laws that discriminate against foreign products to the benefit of domestic products. So Malaysia couldn't pass laws that would benefit its own internal industry but discriminate against foreign industry. That's the first point. And I'm not saying Malaysia does that, I'm just giving you an example. Second is the most favored nation concept. That means if your government has passed a law that gives benefits to products coming from a certain country, it then has to afford those same benefits to products from all other countries that are also signatories to these agreements. And the final is governments should not pass legislation that acts as a barrier to trade. And these treaties, they stand for these propositions, but they also contemplate exceptions to the rules. So if government can justify a quote-unquote violation, it can do so by saying we have a legitimate government objective, and there are a variety of those objectives. One is national security, protection of human health, animal health, consumer protection, and other legitimate objectives. And I would argue that protection of the right to practice your religion as you see fit is another one of those objectives. Now, even if the objective is legitimate, you still don't that doesn't get you all the way. The government, in passing a law that would arguably be a barrier to trade, has to say it's doing it not only because there's a legitimate objective for doing it, but in addition, it must also establish that there are no other less trade restrictive ways to do it. And I'll give you some examples from my experience a bit later on that. And, again, if in fact a government does pass some legislation that's problematic and violates these agreements, one government can take that other government to the World Trade Organization's dispute panel and argue their case. And at the end of the day, if you win, what the WTO will say is, look, Government X that have passed this legislation, you must bring your legislation into conformity with the international agreements, and if you don't, we're going to allow sanctions against you. The flip side of the coin, and I'm just going to go through this one rather quickly because we're going to talk more about the WTO side. There's also public international law that gives rights to private citizens. And when I say private citizens, typically I'm meaning industry. And these rights arise from bilateral investment treaties, multilateral investment treaties, and free trade agreements. So what do I mean? As an example, governments enter agreements with other individual governments. Just as an example, let's take a hypothetical of Malaysia and the United States. So Malaysia and the United States will enter into agreement whereby they say, look, we want to promote investment between our countries, and we promise each other that if an investor from your country comes to my country and puts money into the ground and invests, we are going to provide all sorts of protections for that investment. And we promise you that we will not allow our government to pass laws that would either expropriate or take away your property without compensating you for it, or we will also provide fair and equitable treatment to your investors based on their expectations. So, example is, we will encourage your investor to come in, we will make them promises, then they come in, put money in the ground, and the next thing you know, we change the rules on them such that it undermines the nature of their investment. That is problematic, and you would have rights under these agreements to do that, to take issue with that. And finally, there should not be any discrimination between investors. Now, if there was a dispute that would arise under these types of agreements, you can bring such a dispute before it's called the ICSID, which is the International Center for the Settlement of Investment Disputes, that sits in Washington, D.C., and has a loose affiliation with the World Bank. And I won't go into sort of how you prove that case, but I think both government and also importantly industry needs to keep this in mind when you are thinking about putting money in the ground and investing in various investments related to the food industry. Be mindful of whether there are agreements between your government where you sit and the government in which you're going to, or the country in which you're going to be investing. And of course, if you want to come to me afterwards, I can tell you more about this, but I'm limited on time. Now, the status of halal in the eyes of the law, in terms of this public international law. Notwithstanding the efforts by the OIC and anyone else who's tried to make a difference in this area, there is no international recognized authority or body that grants globally accepted halal certification. Now, why is that? I'm not a halal scholar, I'm not a Sharia law scholar, but my sense is it's a difficult process because it's a matter of religious doctrine with centuries of history, and that history is ever living and it continues to evolve. So what might have even been acceptable to a halal consumer 25 or 30 years ago may not be acceptable today. And probably in 25 or 30 years from now, it may be different. Now, notwithstanding the fact that there is no international agreement with regard to the actual halal standards and certification, there is a working group out of the United Nations called the Food and Agricultural Organization, and they got together with the WHO in the late 60s to come up with a book called the Codex Alimentarius, which loosely translated means the food book. And this was really an effort on their part to try and come up with international standards for all issues relating to food, food safety, etc. Now, in that codex, and because governments wanted some clarity around what halal means and doesn't mean, the Codex Alimentarius folks came up with their own definition of halal, which took bits and pieces from different schools of thought. And right now it's sort of a baseline definition, but it doesn't really satisfy most people who are halal consumers and halal certifiers. And what's interesting is the Codex Alimentarius notes that it accepts that, quote, there may be minor differences of opinion in the interpretation of lawful and unlawful animals and in the Slaughter Act according to the different Islamic schools of thought. I'm just going to pause there before I finish the quote to say, well, it's very nice to say it's minor to them. But I mean, if you're a halal consumer or a halal certifier, I don't think these are minor matters at all. I think that quote, frankly, undermines the importance of the issue. Moreover, it says, however, the certificates granted by the religious authorities of the exporting country should be accepted in principle by the importing country, except when the latter provides justification for other specific requirements. So what you have here are governments, because industry is pushing them, and saying, look, we need to have some clarity, we need some specific rules we can target so we can try and meet our standards. And so the Codex says, look, if you are in Malaysia and you're going to get food coming from New Zealand, you should accept as a matter of principle the New Zealand certification unless you can justify your reason for deviating from that standard. I have a problem with that. I don't know why that should be. As a general matter, the Codex counts as an international standard. And if you're going to deviate from international standards in your own national legislation, you have to justify that. But I think this is sort of not fit for purpose. The Codex Alimentarius, in my view, is not something. It's not a platform or a talking place for matters of religious difference or religious interpretation. So already we've got a problem here where the system is not fit for purpose. Moving on. So now here's where it gets interesting. When I'm talking about the use of public international law to protect halal integrity. So you have governments who say, look, we've got industry, we want to export our goods, we've got a standard, we go to the Codex Alimentarius, we open up the book, we comply with that standard, we should be able to rely upon that, and any government who's going to put additional requirements on us, it's unfair, it's a barrier to trade, it violates WTO rules, and they need to justify it. Now, as I mentioned before, there are a variety of agreements that we talked about. One of them is the TBT, or Technical Barriers to Trade Agreement. And every year, various governments get together, or several times a year, and they meet at the Technical Barriers to Trade Committee, and they have discussions around things that they're concerned with. And in fact, some governments come up with reports on an annual basis to discuss what issues they're facing. And so the U.S. is pretty good with coming up with these reports. And their 2011 report, I took a look at it on the way over here, I thought it was pretty interesting. The U.S. report on technical barriers to trade said as follows: the U.S. industry continues to face market access barriers for halal products. While the Codex General guidelines for use of the term halal are helpful in setting out basic principles, governments have established halal standards that vary significantly based on which of the four predominant Islamic schools of thought a country embraces. First point, I think the U.S. is already doing some of your work for you in the sense they're saying Codex really isn't an international standard, right? It's just it's a starting point for discussion, but they're saying different standards vary significantly. And then they say U.S. industry has encountered difficulties in exporting halal products because of differences in how countries regulate slaughtering, handling, and transportation, labeling and certification for halal purposes, as well as when governments exceed the Codex halal guidelines. And then they took a jab or a swing at Malaysia. And I said, as one example, Malaysia's adopted a standard that would require halal food to be processed in dedicated halal facilities, whereas the Codex standard recognizes food as halal if it is processed on a dedicated line within a facility that produces non-halal products. Now, I mean, you could see sort of where the dispute arises, right? You have industry telling the U.S. that Malaysia is a signatory to these agreements, and as an example, Malaysia has taken really a leading role internationally in trying to come up with standards. They've put the bar a bit higher, and then the U.S. is saying, well, this is problematic for us because it deviates from the international standards, and we think it's too difficult, and therefore is an impermissible barrier to trade. And the governments get together, they talk about these things to try and work out the differences, etc. It's a lengthy process. But there's another point I want to bring to your attention. They say in the U.S. TBT report, while some governments have attempted to frame their halal rules as a food safety issue, the United States has consistently viewed halal as a process and quality standard with no inherent food safety component. So remember back we talked about if you're going to deviate from an international standard, you need to frame your government objective as a legitimate government objective. And I guess here's my first piece of advice. When you are writing these standards and when you're going to develop your own international or your halal certification standards, be very careful about how you frame the objective. Why are you doing this? I would argue to frame the objective, you should also make reference to the fact that this is for religious reasons, not simply for consumer protection. And the reason why I say that is, first of all, no one's going to argue, or no one can really argue with you from another government's perspective. If you say, this is the standard that our religious leaders have said we need to hold the registration or the certification to, there's no less trade restrictive way to do that. If your view is this is what we need, then there's no other way to get around it. If you simply leave it as a consumer protection concept, you can come up with different ways to deal with consumer protection, and I'll give you an example at the end of how we sort of used that against the EU last year in connection with a food labeling regime. So, first piece of advice for governments or religious leaders who are helping or consulting on the development of national halal registration standards, make sure when you're discussing it, you're talking also about religious reasons, not simply consumer protection. It seems like an obvious point to you, right? It's why you're all here, for certification on the religious issue, but it's important to get it into the document, in my opinion. Now, here's another example of where we could apply that. If you look at the Malaysian Protocol for the halal meat and poultry productions, there's a nice introduction at the beginning of that document. And it says, the Malaysian Protocol for the halal meat and poultry productions is subjected to periodical review according to the current needs of the local and international industries to keep abreast of progress in the industries concerned. That's fine, and that's good, and I take that for what it is. I would argue that to protect the interests of Malaysia or any other government that's going to develop these national standards, talk about it also in the sense of we're doing a periodic review to meet the evolving consumer demands / religious needs. Because as I said before, what may have been acceptable to a halal consumer 35 years ago is not necessarily acceptable today, and in 35 years from now it might be different as well. So it's not just an issue for industry, but I would tie it also to the religious needs of the consumer. Here's another sort of example of how I think why I think it's important to talk about the religious objective when you're defining these standards. The June 2011 TBT committee meeting, as I mentioned, remember the governments get together and discuss their concerns and problems they have with each other in relation to barriers to trade. There, the U.S. stated that it was, quote, important to ensure that Malaysia would continue to allow mechanical slaughter of both poultry and meat as long as the process would fully allow for the required ritual slaughter methods. Now, whether that's the case or not, I'm fairly certain that some people would disagree that mechanical slaughter is or isn't okay. It's not my area of expertise, but my point is, why should you be locked in? You should decide, consumers should decide, government certifiers should decide, not sort of either some foreign government on the one hand or industry on the excuse me, or industry on the other. That's why if you work into these documents that in fact we're dealing with these issues because there's an evolving concern amongst consumers to meet their religious needs, you have wiggle room. You have wiggle room to develop, and you have wiggle room to expand your certifying process. Here's just a good factual example of this. In June to August of 2009, there was an independent survey commissioned by the Halal Monitoring Committee in the UK to understand scholarly opinions on halal in the UK. And you'll see these numbers are somewhat staggering, and fair enough, I think the HMC was coming at it from a specific perspective. But the point is there's diversity of views on issues of stunning, as we heard yesterday. And in fact, various scholars, and here, at least in the UK, an overwhelming number of the halal scholars indicated that they would prefer slaughter without any type of stunning. So again, the issue is, I'm not taking a position on what's right and what's wrong with regard to Sharia law, but it should be halal certifiers and national governments who are trying to protect that integrity, the integrity of that food chain, to make that decision. And it shouldn't be bound up in another government's view of what is or isn't trade restrictive. So here's another example of why, when you're coming up with these these standards and these certifications, that you should make clear in those documents that in part it's because of religious needs. Last point on the use of public international law to protect halal integrity. In 2011, there was a report from the EU Trade Commission on potentially trade restrictive measures, again coming after Malaysia, on their standards. And they said exporting meat products to Malaysia is facing increasingly serious non-tariff barriers in the form of new and stricter but non-transparent halal requirement, a cumbersome, costly, and non-transparent inspection regime, and unclear and often contradictory information from the competent authorities. All right, well, I think the EU is a little bit more worked up than the US was on this. Although I take it, I'm not going to pass up an opportunity to sort of say, should we take this with a grain of salt? Let's not forget that the EU comprises of countries, many of which are hostile to religious matters of this sort. We just had the French Prime Minister last month saying that religions should think about whether they should keep traditions that don't have much in common with today's state of science, technology, and health problems. And again, in June of 2011, Holland tried to ban the slaughter of meat without stunning. Again, totally insensitive to religious needs of various communities. But nevertheless, Europe made its views known with regard to Malaysia's protocol. And so I think another piece of advice, one of their concerns is transparency, and that's one we can easily deal with. So if you're going to have a new standard in your country relating to halal certification, you give notice to any potential governments that could be impacted. You do that through the WTO. You should be talking to your governments about it. You should be talking to your ministries of trade about it. You give people notice 60 days in advance. You should probably be talking to the industries that are going to be impacted before that, because they're the ones who are going to wind up the governments in any event about this. And I think the other way to protect yourself against claims that you're being protectionist or that your certifications are true barriers to trade is if you offer free training for certifiers. So, if the U.S. is complaining about Malaysia's protocol, say, no problem, send over anyone you'd like and we'll train them for free, right? I mean, there's ways to sort of be smart about it. Let me just come at it from the other perspective. I'm sure I'm running late on time. This is where you can use WTO or international trade law to overcome discriminatory legislation. Here was the fact pattern. It's true. I worked on it, and this is what we did. The EU had a proposal that was part and parcel of a piece of food legislation. And late in the day in that process, a member of the European Parliament from Germany added an amendment to that proposal. And the amendment said that meat and meat products derived from animals that have not been stunned prior to slaughter, i.e. have been ritually slaughtered, must be labeled meat from slaughter without stunning. Now that captured some halal meat imported and or sold in the EU. And the resolution, here we go, remember again, what is the government objective? So the EU said, why are we doing this? We're doing it because consumers should be informed that certain meat is derived from animals which have not been stunned. This will enable them to make an informed choice in accordance with their ethical concerns. Now, I mean, I don't have an objection to that in theory, but in practice, the problem is that if consumer information is really the government objective, let's tell them everything. That is, we should tell them that these chickens were electrocuted and these pigs were gassed and these animals were killed this way. Why are we simply picking up on one particular method of killing and trying to say that this method of killing is somehow different? Right? My view was this was sort of their effort to delegitimize religious practice, in my view. And in any event, our position was, frankly, that amendment would not have provided consumers with full knowledge of the facts, right? There are misstuns, there are different modes of killing, there's different modes of stunning. So if your position is consumers need to know how the animal is getting from the farm to the fork, let's tell them everything. Let's not just pick on one group and tell them about that. The farmers went absolutely bananas, right? I mean, they just did not, they were, once we started making these arguments, we got the farmers on side because the last thing they want is every manner of killing to be labeled on the food. So we said, so that was the point, that you're not really trying to tell consumers what they need to know. Our argument went further to say that if Amendment 205 had been passed, the result would have been to single out and pejoratively label meat products derived from slaughter without stunning as a second class of meat, right? It's sort of this less ethical meat. And that would have distorted the international trade in those products and presented an impermissible barrier to halal meat exporting countries' ability to compete in the broader meat trade. Now, not every halal meat or abattoir stuns. Most do, but some do not. And so why should they be at the short end of the stick in terms of trade? And we went further with the argument and said that as a member of the WTO, the EU is a signatory to these agreements, and they have to abide by them. And if you pass 205, you're going to violate those agreements. 2 more slides, then I'm done. And so then what we said was, all right, so look, let's look at the text of the Technical Barriers to Trade Agreement. It says, technical regulations shall not be more trade restrictive than necessary to fulfill a legitimate objective, taking account of the risk that non-fulfillment would create. So first we said, number one, what's your legitimate objective here? And second of all, is there a better way to skin the cat? Is there a better way to get consumers the information without being trade restrictive? So on the objective side, we said, it is not a legitimate objective to for a government to single out one type of killing for animals and leave others alone. That's not fair. I mean, it just basically creates sort of an apartheid status with regard to meat that was slaughtered without stunning. Second of all, we said, there are less trade restrictive ways to do this, right? If consumer information is the issue, then allow those producers that want to hold themselves out as more ethical to voluntarily label their products as such, sort of the way organic used to be in the EU and the way it still is in the US. Let them hold themselves out, and the consumers who want to pay a premium for that product can go and look for those products. I mean, my wife likes to buy free-range eggs. I don't understand it, but so she's willing to pay a premium for that, and those people who make the free-range eggs label it. So, I mean, there's an easier way to do it. You can get there, and the consumers can get the information, and the marketplace will allow the manufacturer and the consumer to find each other without making a second-class citizen out of the meat that was slaughtered without stunning. And so we were able to beat that issue back, and then in December of 2010, the Council of the EU published the agreement on the proposal, and it did not contain any provisions mandating the meat derived from slaughter without stunning label. So that's my presentation. I'm sure we'll have time for questions after. Thank you very much.